Thank you. Ms. McMahon, thank you for being here today. Secretary Liu's Chief of Staff, Chris Wiedemann, briefed the committee in November 2012 and stated that a thorough legal analysis was not conducted related to the availability of tax credits in Federal exchanges because it wasn't one of the most significant issues considered in the 36B regulation. Was this also your perspective?
Congressman, I'm not familiar with Mr. Wiedemann's comments. I guess I could say from my own perspective, we did consider this question a serious issue. We analyzed it in a serious manner.
Okay. So you feel that you did do a thorough legal analysis?
Yes.
And can you give me examples of what that was? What was the thorough legal analysis?
Well, members of the IRS and Treasury Working Group looked very carefully at the provisions of 36B itself, at other relevant provisions of the Affordable Care Act, including Sections 1311 and 1321, which address the establishment of exchanges and, as I said earlier, make clear that the Federal exchange is intended to be the functional equivalent of State exchanges. There are other provisions of the ACA as well that relate to the advance payments of the premium tax credit.
Excuse me. Did anyone raise the issue that IRS's and Treasury's interpretation of the tax credit availability in Federal exchanges would have enormous tax and spending implications?
Congressman, we believe that our interpretation of the statute is consistent with the way that the Affordable Care Act was scored by the Congressional Budget Office and the Joint Tax Committee.
Okay, well, that's not the question I asked. But did the IRS or Treasury's analysis at any point factor or consider whether Congress made tax credits available only in State-based exchanges as an incentive for States to create exchanges?
When we became aware of this question, we also became aware that that was the rationale that was being suggested.
Do you have any evidence that the IRS or Treasury ever considered that Congress made tax credits available in State-based exchanges as an incentive for States to create exchanges?
Congressman, in the course of our rulemaking process, we did look very carefully at all of the legislative history relating to the Affordable Care Act, and we found nothing to suggest that the sort of incentive rationale that you're suggesting.
Is there any evidence to support that you did this? You say you did this, and you say there was a thorough investigation. Is there evidence to support a thorough investigation? I mean, remember we got like a half-page brief. Is there anything to show this? You say this, but we're not seeing it.
Congressman, I would simply refer you to the letter that we sent this morning regarding our concerns with release of additional documentation.
Okay. Did Treasury factor into its analysis that ObamaCare's author created large financial incentives, such as an exchange establishment grants, to cover the cost of States creating exchanges, and that the author failed to create any specific funding for the creation of Federal exchanges?
Congressman, I don't recall whether that point was explicitly considered during our rulemaking process.
Okay. All right. On October 12, 2012, Mark Mazur, Assistant Secretary for Tax Policy, wrote a letter to Chairman Issa on the tax credit rule. Mazur wrote, "Throughout the ACA, Congress refers to the exchanges as exchanges established by a State, and exchanges established under the ACA. There is no discernible pattern that suggests Congress intended the particular language in Section 36B to limit the availability of the tax credit." Did you review this letter?
Yes, I'm familiar with the letter.
Okay. Can you tell us how the IRS and Treasury searched for a pattern for references to exchanges in Obamacare?
Well, Congressman, IRS and Treasury staff attorneys looked through the Affordable Care Act, and examined all of the references to exchanges to try to determine whether there was any particular convention that Congress had used in describing state or federal or exchanges or both, and as the letter indicates, we were not able to find it.
All right. When an agency working on a complicated rule is searching for a pattern in the way Congress referred to certain terms, would you expect them to categorize or organize these results? I assume you would, but I don't mean to put words in your mouth.
Well, Congressman, as I've said, our working group did a very thorough analysis.
Did you categorize or organize the results?
I'm not familiar with.
Okay. Do you know that the IRS and Treasury employees have admitted to committee staff that no one at either IRS or Treasury ever categorized or organized references to exchanges, or exchanges established by a state and exchanges established under the ACA in any way?
Congressman, I'm not familiar with the comments that you're referring to.
Okay. Do you think it is a problem that no one at IRS or Treasury categorized or organized all the references to exchanges established by the state under Section 1311 in order to determine whether a discernible pattern exists?
Mrs. McMahon, you can answer the question. I think we're running close on time, but you can answer that.
Congressman, the IRS and Treasury Working Group did a very thorough analysis, and I am satisfied that their work, appropriately looked at all of the relevant ACA provisions, and I am satisfied with their conclusion that no discernible pattern existed.
But you can produce no evidence as such?
Congressman, I would simply refer you again to the letter that we sent this morning in which we described our concerns with producing additional documentation.
Thank you, Ms. McMahon.
Thank you.